Good afternoon, ladies and gentlemen. I am Nino Departia, Chairperson of Georgian Lawyers for Independent Profession. GLIP is a non-governmental organization and was founded in 2008 by Georgian bar members. Today we have dozens of members, which includes members of Georgian Bar Association and practicing lawyers. The main goal of the organization is to promote the development of the legal profession, as well as the raising the level of professional independence, relevant qualification, professional skills, and ethics. For this purpose, GLIP organizes dozens of continuous educational projects in Georgia. We have already signed a memorandum with different Georgian institutions, including the High School of Justice of Georgia and High Council of Justice of Georgia. In recent years, GLIP has strengthened cooperation with its foreign partners and made numerous visits to various European institutions, including European Court of Justice. The Council of GLIP considers that international cooperation is very important for Georgian lawyers. It is a great chance for sharing experience and knowledge. Several months ago, we have started cooperations with the National University of Singapore. Today, it is a great honor for me to be the host of a webinar on international investment arbitration law with the Center for International Law of the National University of Singapore. It is the first mutual event with GLIP and CIL. We have very good plans for future collaboration. For example, we have already planned a visiting seminar in CIL for our members and Georgian lawyers. In 2017, I was participant of Arbitration Academy in National University of Singapore. According to my personal experience, I am sure that collaboration and joint project with Singapore National University will be a great contribution for Georgian lawyers and bar members. Today, it is a great example and the first event between CIL and GLIP. The content of the webinar includes an overview of Georgian law and the practice of the Supreme Court of Georgia, as well as the characteristic of investment arbitration and the practice of exits. On behalf of my members and council, I want to express my great gratitude to the Director of Center of International Law of National University of Singapore, Mrs. Nilofer Orl, Mr. Ramesh Viramentri, Mr. Brian Chang, Research Associate of CIL. Today's event could not have taken place without their help and involvement. In the end, I would like to thank all panel members. It is a great honor for me to introduce the speakers of the webinar. Professor Ramesh Viramentri, the head of the International Dispute Settlement at the Center of International Law at National University of Singapore, Professor of Faculty of Law and Counsel at Clifford Chance. Professor Janis Kalamida, Head of the Investment Law and Policy, Center for International Law at National University Singapore, Research Associate Professor at Faculty of Law. Justice Nino Bakakuri, a member of Supreme Court of Georgia. Mrs. Bakakuri is also a representative of Georgia at the European Commission for the Efficiency of Justice and a member of Consultative Council of European Judges at the Council of Europe. Justice Bakakuri will make a presentation on the practice of the Supreme Court of Georgia on recognition and enforcement of foreign arbitral award. And last, but not at least, I want to say special thank you to Mrs. Irina Chanksaliani, Head of International Legal Project of GLIP. She also works as an International Arbitration Service Consultant. Mrs. Chanksaliani's efforts are immeasurable in terms of international cooperation opportunities for GLIP, and especially for this project. She now is presenting on the topic of Foreign Investment Legal Framework Act in Georgian law. I want to give an opening speech and pass my microphone to Director of CLIA, Mrs. Nilofer Orl, and to express once again my great gratitude and great and special thank you to her and staff members of CIL and speakers also.
Thank you so much, Nino. And may I start by greeting my dear Georgian colleagues, and I hope my pronunciation is okay, Gamar Joba from Singapore. As director of the Center for International Law, it is my privilege to welcome you to the GLIP-CIL joint webinar and to make a few opening comments with my dear colleague, Nino Liparcia, the president of GLIP. CIL is a university-level research institute at the National University of Singapore, which is one of the top global centers for higher learning. The mission of CIL is to enable Singapore and the Asia-Pacific region to play a more significant role in the promotion and development of international law. So I'm absolutely delighted that from Southeast Asia, we are partnering with our colleagues in Georgia from the beautiful Caucasus region in holding this webinar on international investment arbitration law. The CIL is committed to promoting international law not only in our region, but globally. A rules-based system of international law is central to the functioning of any peaceful dispute settlement system. Investment law and international dispute settlement are part of the core areas of work of the CIL. Our past and present staff count among the leading names in international investment law, international arbitration, mediation, and conciliation, including our panelists today, Professors Ramesh Veeramantri and Janssen Kalamita. And we are extremely honored to collaborate with our Georgian colleagues, and especially to have on the panel a member from the Georgian Supreme Court, Justice Nino Bakakuri, and the very prominent lawyers from the Georgian Lawyers for Independent Profession. And as I come to my conclusion, I also would like to thank the wonderful CIL team. And of course, I should also recognize and thank dear Irina Changselani for all her efforts as well. At CIL, we look forward to a continued collaboration between Singapore and Georgia, and hopefully after the pandemic, to welcome you to this beautiful area in Singapore. I wish you all an excellent webinar today, and thank you so much.
Thank you, Mrs. Oral. Now, I'm sure that today's webinar will be very fruitful for participants and interested people. It will, and I'm sure that it will be a very good start for future long-term cooperation and collaboration between CIL and GLIP. Now I want to ask my colleague Irina Changselani to be a moderator of today's webinar. Hello, Irina. Please.
Good afternoon, everybody. Thank you very much to Ms. Liparcia and Ms. Oral for their opening and willingness to be involved in organizing such events in investment arbitration. It is my greatest pleasure to speak at this wonderful event, and I truly hope that this webinar will be a starting point for future cooperation between the CIL and the GLIP, and we work on very interesting projects together. And I confirm my respect to the distinguished panel members with fascinating and immense experience in international investment arbitration. I especially thank Professor Veeramantri for his involvement and for his immediate reaction to our cooperation request. Professor Veeramantri, once again, thank you very much for your valuable input in this project. It is greatly appreciated. Now let me move to the main part of my presentation. Before I start speaking about foreign investment legal framework under Georgian law, I want to shortly review an arbitration milieu in Georgia. I want to underline that improvement of Georgia's business environment has been defined as one of the key priorities according to the EU Association Agenda. In the context of facilitating economic development through a better legal system, the association agenda confirms the need to develop mediation, arbitration, and sets introduction of fair and efficient and more widely used alternative means of dispute settlement as a matter of short-term priority. Moreover, a single support framework for EU support to Georgia explicitly refers to mediation and arbitration indicators for broader access to justice for vulnerable categories of population. Currently, we can say that we still have some challenges in arbitration field in Georgia, but let's not speak about the challenges, and let me move to continue in a positive note. And I say that in 2009, as part of Georgia's strive to become attractive for investors, a new law on arbitration was adopted. This law is entirely based on ancestral model law and incorporates the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. We can say that the process of development is still ongoing, and a lot of efforts has been done in order to raise the legislative and professional standards for the development of arbitration in Georgia. To name that is that in 2013, the Georgian International Arbitration Center, GIAC, has founded, and it is the first non-profit arbitration institutions in Georgia. The GIAC mainly deals with international arbitration disputes, and it is noteworthy to mention that after 2013, there is a noticeable increase of caseloads in the center, which can be assessed also in a very positive way. At the same year, the Association of Arbitrators have been established, which is the first professional body of arbitrators in Georgia, which sets the standards, codes of ethics for arbitrators, and creates accreditation systems for arbitrators as well. Let me move to the main part of my presentation, I will be speaking about national investment protection legislation, bilateral investment treaties, and multilateral legal instruments. If time allows, of course, I will cover other relevant laws concerning foreign investment protection framework. Firstly, I would like to mention that Georgia is in the category of states which is oriented to attract foreign investment. So the Georgian international investment protection legislation is structured in a way that tries to have all the regimes and protections covered. Guarantees for protection of investments are determined by the Constitution of Georgia, international agreements of Georgia, and we also have the two main laws on foreign investment protection. First is on promotion and guarantees of investment activity, and the second law is on state support of investment. The law on promotion and guarantees of investment activity determines legal grounds for the implementation of both for foreign and local investments in the territory of Georgia and guarantees for their protection. This law is intended to define a legal order to promote investments. It is important to mention that this law does not differ national and foreign investors and establishes the same protections equally for the foreign and local investors. Article 3 of the mentioned law provides a national treatment provision according to which during implementation of investment and entrepreneurial activities, rights and guarantees of foreign investors may not be less than rights and guarantees enjoyed by natural and legal persons of Georgia. A second issue is what I want to mention is the question, as we know that question of what constitutes an investment can be a critical threshold jurisdictional questions in questioning investment arbitration. We should definitely mention what constitutes an investment under the Georgian law. The mentioned investment law mainly provides the asset-based definition of investments, and according to this law, investments are considered to be all kind of property until intellectual values or rights that will be invested and used in the entrepreneurial activity carried out in the territory of Georgia and to gain profit also. We can say that the list is not exhaustive. Accordingly, we can consider that other assets that is not directly mentioned in this article can be considered an investment and be in the category of protected investments. The law is also providing different protections such as safety of investments, compensation upon deprivation of investments, prohibitions and limitations related to implementation of investments, labor relationships, social protections, pension provisions, tax return treatments, tax treatments also related to investment activities, and etc. The second law that we have is on foreign protection, is the law on state support for investments. This law is intended to promote investment by improving the procedures necessary for investment and business activities and by creating an additional legal framework. The law applies to all foreign and domestic investments made and used in the territory of Georgia. Also, this law determines special norms and additional support measures to encourage investments of special importance. According to the mentioned law, investors that are planning to make an investment with a total amount of 800 GEL or an investment that functionally and strategically has a significant influence on the country's economic development and infrastructure may request government of Georgia to award a status of special importance to the investments which is made by them. We can say that this law establishes the special standards for the investments that is more than 8,000 GEL, which can be considered as a tool for attraction of foreign investments. One difference, what is provided in this law is that special importance status investors have special representative, which is a legal entity of public law enterprise Georgia under the Ministry of Justice, Ministry of Economy and Sustainable Development of Georgia. Shortly saying, is the organization that is representing the state of Georgia with the investor relations. This can be considered also the additional attraction, foreign investment attraction standards that Georgian law provides. But it will be very interesting to actually see the view of our experts, what they think about this amount what we have in the law, and maybe later on I will have some questions on this issue with them. I would like to also mention new 2018 law on public-private partnerships, which is a new mechanism for Georgian legal system. By introducing PPP to its legal system, Georgia offers foreign investors sets of procedures and frames, as well as specific guarantees and protections for investments. The law covers the issues related to the concession contracts, and what is important is that according to this law, the concession contracts also falls under the definition of investment. While speaking investment protection legislation and framework, Georgian framework, where generally speaking, not only the investment protection statutes, but all the related legislation as well. This legislative package usually is the law which generally defends the property. We can say that we have all the related legislation that is covered with in terms of speaking on investment protection. But there are some problems in entrepreneurial on the law on entrepreneurial and insolvency proceedings, and about this two law, we can say that there are positive improvements because the new draft amendments are in the third session of parliamentary discussion. So we will have the very new framework in this two law as well. The second part, what I want to cover is the bilateral investment treaties signed by Georgia and also multilateral legal instruments. It is not disputed that the importance of foreign investments becomes vital in the world's economy. The mutual cooperation between developed and developing countries by signing the multilateral and bilateral investment treaties, with its own dispute settlement mechanisms has become very relevant trend in the world. Georgia has not lodged behind this trend and is actively negotiating over this type of agreements with different countries. Georgia signed its first BIT with US in 1995. After that, Georgia has negotiated with more than this kind of treaties with more than 32 countries. We can actually say that in the BITs that are signed till 2013, 13 are not, and they does not have, for example, a clause by clause sophistication that is usually should be included in this kind of benefits. However, it is not surprising, mainly because signing of such an agreement was very new for Georgia at that time. While working on the topic, I reviewed a lot of BITs and BITs signed by Georgia, and it can be observed that there we can group the BITs in the categories that is signed till 2013 and after 2013. Till the old BITs that was signed in, before 2013, they are mainly follow the definition of investments that are broad with non-exhaustive list of categories of assets, and also we can observe that in some of the agreements there is no definition of investments. They don't have, for example, national treatment provision or most favored treatment provision, or in some of them we can see the mixture of those clauses. So it can be assessed that it is not the framework that Georgia should have, but it was the different time then, because the arbitration system was almost thwarted at that time, and maybe this also had an influence on the on this kind of treaty negotiations. The BITs signed after 2013 are mainly cover the protection that are more or less in compliance with the international standards. For example, new Swiss Georgia BIT, which is signed recently, using more is actually in compliance with the international standards, and we can see a lot of different protection in this agreement. This Swiss Georgia BIT using more narrow definition of investments, which means that it is focused or to only a closed list of investments. According to the above agreement, property is considered as an investment if it has the characteristics of an investment, including commitment of resources, duration, and risks. While mentioning those characteristics, I'm reminded of a very important decision, Roma versus Uzbekistan case that has actually crucial importance on developing jurisprudence on this matter. With the Roma tribunal, what the Roma tribunal did was that it adopted a slimmed down 3 criteria requirements tests. Although in the context of Article 25 of the Exit Convention. I have mentioned this decision regarding the recently signed BITs because the above mentioned Swiss BIT would be a good example of how good reasoned decisions may form and change the directions and standards of treaties year by year. To move on the multilateral investment treaty signed by Georgia, it can be mentioned that in 1995, Georgia is the party of Energy Charter Treaty, and as Georgia's energy resources are huge, ECT played an important role in the attraction of foreign investments, namely in the energy sector. Although there is a very interesting decision against Georgia, Kardasopoulos versus Georgia, which was based on Greece-Georgia BIT and ECT itself, where tribunal found that the BIT did not cover the issue of indirect ownership of shares in company, was an investment or not. Sadly saying, it is the case that Georgia is awarded of compensation for unlawful expropriation in the amount of 15 million USD. To move, let me move to the to speak about recently signed BIT between Japan and Georgia. This is the first BIT which is signed by Georgia or Japan since the outbreak of the COVID-19 pandemics. The BIT will enter into force later this year when it goes through the ratification process in Japan and Georgia. The first investment from Japan to Georgia was made in 1997. Since then, a total of 2,043 million USD investments has been made by Japan to Georgia. That's why the signing in this kind of agreement with Japan is a very important for Georgia's investment flow. The Japan-Georgia BIT protect investors from Japan and Georgia, and the definition of investor includes Japanese and Georgian nationals as well as enterprises. Enterprise is defined broadly and covers most forms of company organization, trust, partnership, or other legal form of association that is duly constituted or organized under the applicable laws and regulations. An investment protected under the Japan-Georgia BIT, it is also defined widely that it includes property rights, shares, stocks, bonds, etc. However, in order to qualify for protection under this BIT, investments must have been made in accordance with the applicable law and regulations of Japan or Georgia. And investments must also have the characteristics of an investment, which includes the commitment of capital, expectation of profit, or assumption of risk. Among the other rights, the Japan-Georgia BIT includes the key protections for covered foreign investors and investments, and includes national treatment provisions, protection from expropriation and nationalization, fair and equitable treatment, full protection and security treatment, standards, and as for the ISDS standard, we can say that as the other BITs signed by Georgia, the Japan-Georgia BIT contains an ISDS mechanism which allows investor to enforce rights granted under the treaty through international arbitration, specifically to exceed or uncitral. Both Japan and Georgia are members of the New York Convention and the Exit Convention, and it means that an arbitral awards made in favor of a covered investor can be enforced against the relevant state, Japan and Georgia, and the territory of any member of the relevant convention. This is actually what I wanted to cover in my presentation, and now I would like to give the floor to our distinguished Supreme Court Judge, Ms. Nino Bakakuri, who will be speaking about the recognition and enforcement of foreign arbitral awards from Georgian perspective. Thank you for your attention.
Thank you, Irina. It is my pleasure to participate in such an interesting webinar today. My presentation is about Georgian court practice in relation to recognition and enforcement of foreign arbitral awards in Georgia. As we all know, the value of arbitration as a method of settling disputes in international commercial relations is recognized in every part of the world because it contributes to harmonious commercial relations, stimulates international trade and development, and promotes the rule of law at the international and national levels. Since 1994, Georgia has been a contracting state to the New York Convention on the recognition and enforcement of foreign arbitral awards, which is one of the most important United Nations treaties in the area of international trade and the cornerstone of international arbitration system. In addition, recognition and enforcement of foreign arbitral awards is regulated by the law of Georgia on arbitration, which has been drafted according to model ancestral law. Certain procedures are also regulated by the number of other domestic laws, law on international private law, the Georgian civil procedure, and the law on enforcement. The New York Convention's regime for recognition and enforcement has become deeply rooted in the legal system of Georgia and has contributed to the status of international arbitration as today's normal means of resolving commercial disputes. The procedure of recognition and enforcement of foreign arbitral awards is quite simple and straightforward in Georgia. For the procedure of the recognition to start, the interested party shall take motion before the Supreme Court of Georgia, which is the highest court in the country, the Court of Cassation. The decision of the Supreme Court is final, which means that the party does not have to go through various court instances and spend much time to get recognition. The Supreme Court directs the motion to the responding party, which is obliged to submit the response within 7 days. The respondent has a right to request an oral hearing. If she or he does not use that right, the case is decided without oral hearing. Usually, the decision is made within 1 to 3 months. Maximum time is 6 months, established by law. The motions for recognition and enforcement of arbitral awards in the Supreme Court's practice are relatively less frequent today compared to the motions for the recognition and enforcement of foreign court decisions. In the process of dealing with the motion, the Supreme Court will not re-examine the subject matter of the case. It will only review existence of the grounds for denying recognition and enforcement that are stipulated in Article 5 of the New York Convention and Article 45 of the Georgian Arbitration Law, which lists exactly the same grounds as the Convention. Georgian Supreme Court follows the same principles as are established by the New York Convention in relation to court review standards and the allocation of burden of proof between the parties. In particular, Georgian Supreme Court shares the Convention's pro-enforcement bias, the general principle set forth by Article 3 of the Convention, according to which foreign arbitral awards are entitled to a prima facie right to recognition and enforcement. The Supreme Court has emphasized this principle in almost every decision. The grounds for refusal under the New York Convention and the Georgian law are the following. The parties to the arbitration agreement were under some incapacity or the agreement is not valid under the law to which the parties have subjected it, or failing any indication thereof under the law of the seat of arbitration. The party against whom the award is invoked was not given proper notice of the appointment of the arbitrator or the arbitration proceedings and was otherwise unable to present the case. Award deals with a difference not contemplated by or not falling within the terms of submission to arbitration, or it contains decisions on matters beyond the scope of submission to arbitration. The composition of the arbitral authority or the arbitration procedure was not in accordance with the agreement of parties or with the law of the seat of arbitration. The award has not yet become binding in the parties or has been set aside or suspended by a competent authority of the seat of arbitration. These grounds are examined only with the request of the party against whom the award is made. Only if the party furnishes the court with the proof thereof. So the burden of proof of these grounds is on the respondent party. Recognition and enforcement may also be refused if the Supreme Court finds that the subject matter of the difference is not capable of settlement by arbitration under the law of Georgia, or the recognition and enforcement of the award would be contrary to the public policy of Georgia. These grounds, these two grounds, are examined ex officio, which means that they are examined by the initiative of the Supreme Court, despite the fact whether respondent states these grounds or not. The New York Convention establishes a ceiling or maximum level of control for the enforcement of arbitral awards, leaving each state free to act less restrictively. There have been a number of interesting cases where some of the grounds for refusal were the subject of the Supreme Court's review. Number of decisions of Georgian Supreme Court are listed on the website of New York Convention. I will discuss only two of them since we don't have much time. At first, I would like to discuss the only case so far where the Supreme Court has refused the recognition and enforcement of the arbitral award, which was made in 2015 by the single arbitrator in London, UK. The subject of the dispute was the trade agreement between the parties. Its Article 5 contained the arbitration agreement. Based on this article, the applicant proposed to the respondent to appoint a single arbitrator to decide the case. The respondent did not reply to this proposal. The applicant applied to the UK court to appoint the arbitrator. The UK court appointed the single arbitrator pursuant to the arbitration agreement. By this decision, and according to the UK law, the competence of the arbitrator was established. The ground submitted by the respondent at the Supreme Court of Georgia to deny the recognition of the arbitral award before our court were the following. Under Article 5.1a of the New York Convention, the arbitration agreement is not valid under the law to which the parties have submitted it or under the law of the seat of arbitration, which in this case was UK. The respondent claimed that the wording of the agreement was not sufficiently clear to consider it as an arbitration agreement. It does not contain the parties' agreement on the substantive issues related to the arbitration. Our respondent also claimed that the Georgian and Russian texts of the agreement contradicted each other. Another ground for refusal was Article 5.1b. The party was not given proper notice of the appointment of the arbitrator and of the arbitration proceedings. Also, additional grounds were Article 5.1c, matters beyond the scope of submission to arbitration. 5.1d, the composition of the arbitration authority was not in accordance with the agreement of the parties. And the final ground was 5.2b under the New York Convention, which is recognition and enforcement would be contrary to the public policy of Georgia. Regarding this ground, the respondent claimed that arbitration agreement was contrary to the public policy of Georgia, since it does not contain the name of any particular arbitration institution, which is the mandatory rule established by the law and the court practice in Georgia. What was the Supreme Court decision? In relation to the ground under Article 5.1a, arbitration agreement is not valid. The court examined the arbitration agreement and found that there was really a significant difference between Georgian and Russian texts. The Supreme Court decided that the name of the Article 5 in the trade agreement between the parties, the name was arbitration, was not sufficient to conclude that the parties made an arbitration agreement in the circumstances when the text of Article 5 itself did not contain any clear wording on this issue. The text of Article 5 only stipulated the following: in case of dispute, it shall be decided pursuant to the UK law. The place of jurisdiction is London. So the text of Article 5 did not contain any agreement, any indication about arbitration. It was only in the title of the Article 5. The word arbitration was only in the title of Article 5. The court did not share the argument by the applicant that this agreement was valid agreement, valid arbitration agreement under the UK law because of the lack of sufficient evidence. And since it did not have enough evidence to speak about UK law, the court referred to the law and court practice of Georgia. The court examined the text of the agreement and concluded that it was very general and provided for the obligation of parties to make an additional agreement in relation to the arbitration. the court stated that it did not contain, this article did not contain any agreement on any particular arbitration institution. After that, the court concluded that even if the agreement was valid, the arbitration award could not be recognized since there was also a ground for refusal under Article 5.1c, which is matters beyond the scope of submission to arbitration. Based on the aforementioned, the court did not find it necessary to examine other grounds. It is a matter of debate whether we agree to the Supreme Court on this case or not. But I presented this case to your attention since it is interesting as the single case where the Supreme Court refused to recognize and enforce the foreign arbitration award. I will speak about second case, which was decided in 2017, and which is interesting in a sense that in this case, Supreme Court also had to deal with many grounds of not recognizing or not enforcing the foreign arbitral award presented by the respondent. So main grounds in the second case were Article 5.1a from the beginning, validity of the arbitration agreement, but the respondent later waived this ground. Then it was Article 5.1c. Award contains decisions on matters beyond the scope of submission to arbitration. And the last ground was Article 5.2a, not arbitrable under Georgian law. So the matter was not arbitrable under Georgian law. The issue here in the second decision concerned the request of advance payment, which was made pursuant to the service contract between the parties. The service contract provided, provided under this contract did not correspond to the amount of the advance payment. The contract was terminated and the rest of the amount of advance payment was requested back pursuant to the rules of unjust enrichment. The respondent claimed that since the advance payment was requested pursuant to the rules of unjust enrichment, this was the matter beyond the scope of submission to arbitration. This issue was considered by the Supreme Court pursuant to the law of Russian Federation, because according to the service agreement made between parties, which included the arbitration agreement, the governing law was the law of Russian Federation. The court stated that despite the fact that the language of Article 5.1c did not explicitly impose any particular standard of review, any decision by the arbitral tribunal as to its own subject matter of jurisdiction and the scope of the submission to arbitration could not be binding on the enforcing court. The court indicated that the burden of proof of grounds under Article 5 was on the respondent, who did not provide in this case the grounded submission. According to the law of Russian Federation, this was not the matter beyond the scope of submission to arbitration, because dispute related to the contractual obligations. The court also evaluated the same issue under Georgian law in addition, and concluded that the result would be same under Georgian law. So according to Georgian law as well as Russian law, this matter was related to contractual obligation and it was not a matter beyond the scope of submission to arbitration. The court also considered grounds under Article 5.2a, whether the subject matter was capable of settlement by arbitration under the law of Georgia, and whether the recognition and enforcement would be contrary to the public policy of Georgia. On both issues, the court indicated that these grounds were examined ex officio by the initiative of the court and concluded that this case was capable of settlement by arbitration under Georgian law, and it was not contrary to the public policy of Georgia. So the court recognized and decided for the enforcement of this award. In conclusion, based on the practice of the Supreme Court, we can state that it construes the grounds for refusal under the New York Convention narrowly in general. It has exercised its discretion to refuse recognition and enforcement under the New York Convention in exceptional cases only. As I already mentioned, so far, at least during the last 5 years, it has been only one case of refusal from the side of the Supreme Court. With this, I finish my presentation, and I will be open to your questions at the end of this webinar. Thank you, and I will pass the floor again to Irina. Thank you very much.
Thank you very much, Justice Bakakori, for your very interesting presentation on recognition and enforcement of foreign arbitral awards and Georgian practical aspects about it. Now I will give the floor to Professor Veera Mantri, who will be presenting about the main characteristics of investment arbitration. Professor Veera Mantri, floor is yours.
Thank you, Irina. I'm very excited about this presentation and also the collaboration between CIL and GLIP. It's very exciting times, I think. I think we're entering a period of a bit of uncertainty in a globalized world, trying to cope with many different factors, and it makes me think that there are very exciting times ahead, especially when Singapore is talking to Georgia about these, the globalized method of international dispute resolution. Two very, very strong and long-running limbs of those aspects of globalization are the New York Convention and the model law. Here in Asia, we find that most countries, I would say 90% of countries here, we use the model law as the basis of our domestic legislation to supervise or control arbitration. So with that, lawyers in Asia, right, will understand the laws in Georgia because you use the same foundation. And lawyers in Georgia will also understand many of the Asian laws. It's a very, very good starting point for international collaboration and globalization, where we are having more and more trade cross-border, across nations, across just different jurisdictions, across different legal systems. And to have that foundation is a very, very good start. Obviously, it depends on the court system and how courts interpret those pieces of legislation or international instruments. That sounds like Georgia is very active, and it seems like it's doing it in the way that the drafters of the model law, the drafters of the New York Convention envisaged. So I'm very happy to be hearing, your Georgian interest in this globalized framework, but also I'm very happy to be a part of this collaboration. So with that very quick introduction, I'd like to now just focus on my topic, which is international investment law and its main characteristics. Excuse me, I just need to start the slideshow. So if everyone can see that, what I'd like to cover very quickly, I know we've got limited time. What I'd like to cover is, what are the sources of investment arbitration? How is the power to go to investment arbitration derived? What are the fora? What are the different types of jurisdictions? What are the different types of systems involved here? And then I'll start looking more at the content of international investment arbitration and investment law. You know, what you look for to establish jurisdiction in an international arbitration. Then I'll look at the grounds, the merits grounds that are often used in investment arbitration. I'll then turn to state defenses, and finally I'll wrap up with looking at enforcement and how investment arbitration awards may have to be enforced. So back to the first question, the sources. I will focus on treaties. So and so that's one of the main bases for investment arbitration. So usually, you know, you look at the bilateral investment treaty between the two countries. And if you are an investor that needs to needs the arbitration route, hopefully you don't, but if you do need the arbitration route against a state, then you would be looking for treaty language that gives consent to arbitration. Now, there's a lot of case law about this, but generally I would summarize the case law as saying this consent needs to be clear. It has to be very clear that the state has consented to an investor, that investor can bring a claim against the state. The perfect language, I would say, would be in a treaty. It would say the state hereby consents to arbitration. So that's the sort of ideal language. But you know, I've been practicing and dealing with this area since about 2008. And I've looked at hundreds of treaties, and I see so many different variations in the language of consent, which many times brings about disputes about whether consent was given. So one very quick example is I was in a case and the language said shall consent, the state shall consent. So this became a very significant jurisdictional issue. What does shall consent mean? Is it futures consent? So, and what if the state doesn't actually provide the consent when the request for arbitration is made? Does that still mean that there's no consent? Because there, and the argument by the state in that case was, well, shall consent means a second consent needs to be provided once the arbitration request is filed. If that second consent is not given, then there is no consent. So there's cases about that, but again, the wording of the treaty made that a bit unclear about what that means. So treaty language is absolutely paramount. It should be very clear to either side. If you don't have clear language, potentially you have a large jurisdictional objection about consent. So that's consent in a treaty. You have contractual consent through contracts between a state and an investor. So that could be the basis of the consent to arbitration. And then more rare, less often, you get legislation in a state that consents to investment arbitration. So one famous case was SPP against Egypt, where Egypt in the 70s had a law that actually gave consent to an investor in Egypt to bring an investment arbitration case. Just very quickly, I just looked through the UNCTAD website that lists investment treaties all around the world, and that states that Georgia has signed 38 investment treaties. That's essentially bilateral investment treaties, and out of those 38, 33 have entered into force. So Georgia and the other side have ratified 33 treaties. So it's a very good, it seems like it's a good coverage. Other countries, China, for example, Germany, they've signed over 100 investment treaties. So that's one end of the spectrum. And the other end of the spectrum would be countries like India. They signed a number of treaties, but now they're terminating their treaties. So their number of treaties are reducing. And that's, we can have another webinar about this, about the sort of issues raised by investment arbitration. What do civil society, elements of civil society say about this? There's talk about the backlash against investment arbitration, but I think on the whole, most states are sticking to investment treaties. There is criticism when we shouldn't ignore that, but I think generally states are sticking to investment arbitration, but more and more states are modifying the language of these investment treaties, making it more certain, and often taking on board a number of criticisms of the system. And so we see an evolution that's taking place, but generally, investment treaties are not sort of disappearing. Many states are still adhering to those international instruments. Very quickly here, this is from the UNCTAD database again, the number of treaties globally in force. And you'll see, I think what's very interesting is if you can have a closer look at the graph there. So from about 1993 to 2000, there's a peak in the numbers of treaties. And that's where, there was a very, very positive outlook on investment treaties and the need for these, especially in your region in Georgia, when a lot of the former Soviet states were sort of opening up and wanting foreign investment. So many states during that time signed up to investment treaties, and that's one of the reasons for the spike in the numbers of investment treaties. But as you see, there's a spike. It's gone down a bit, but that could also be because so many treaties have been signed now. But there is a general sort of decline, but that still doesn't mean the previous treaties don't have effect. They still have effect, and there is a very substantial global framework of these treaties still in place. This slide represents the number of investment treaty arbitrations. You'll see two colors. You'll see the green. Green represents ICSID arbitrations. The orange represents non-ICSID. So that could be a various number of other types of institutions that handle investment arbitration. But as you'll see, ICSID is by far the most popular in terms of where you go to conduct your investment arbitration. As you see here, very different from the previous graph, there's an increase. It's an increase, it's not a decrease. So I would say that increase has been caused by the spike in the 90s often, and so those treaties are there. People are starting to know about it, and their investors are starting to use it more and more. Not my NUS work, but my work at Clifford Chance, we have more and more clients coming in when they're structuring their investments into a country. They want to know what the protections are. They want to know which treaties will protect them more. And there's there's more and more work I do on the front end deal making rather than the back end dispute settlement. When you're making the deal at the front end, I, as a disputes lawyer, am now being consulted to advise corporations as to what their treaty protections are. So more and more I see a very big uptick in corporations wanting to know what their investment treaty rights are before they make that investment. Now, in terms of arbitrations against Georgia, I have located 13. Many have settled, you can see here. I won't go through them all. Some have discontinued, and a number where the investor has succeeded. So that's I'll leave that to you. I'll have these slides freely available after the webinar for people to have a look at. Now, in terms of fora, this is where we go back to ICSID. I'll just touch upon ICSID. The other types of institutions, especially in investment arbitration, are quite, there's a lot of sort of different uses of different institutions, but the Permanent Court of Arbitration, I would say that would be number 2 in the popularity when it comes to choosing your fora when you want to bring an investment arbitration claim. So starting with ICSID, ICSID is governed really by the ICSID Convention. So some people call it the Washington Convention, the 1965 ICSID Convention. That provides you with the whole framework of how the ICSID arbitration process works. That and that's very important. The convention is the bedrock of any ICSID claim, but you need to think about the ICSID convention and also the ICSID arbitration rules. So those two instruments go together, they work together. So your convention is the most important thing, but don't forget the ICSID rules also provide you with guidance on how the procedure works once you commence an arbitration. Now, and this is when I teach arbitration at NUS, I like using ICSID because it's a great comparative instance when you're trying to get students to understand the seat of the arbitration, right? So ICSID does not have a seat. Now, when I mention seat, right, in a typical arbitration, I think almost all arbitrations, commercial arbitrations, have a seat. That's the place, that's the legal place where you have the arbitration, whether it's Georgia, whether it's in London, whether it's Singapore. If you say the seat is in Singapore, that means that the courts of Singapore have a supervisory role, right, over the arbitration. But in ICSID arbitration, there's no seat. So that's a very, very important difference. There's no seat. So when you have an ICSID arbitration, you don't even need to agree with the other side what the seat is. There's no seat. Essentially, what the drafters of the ICSID convention wanted to do was to basically neutralize the whole process. So there's no interference by courts, right? So it's an insulated procedural mechanism. If you want to challenge an arbitrator, you don't go to the courts, go to the ICSID convention, and that will show you there are mechanisms on how to challenge arbitrators in the ICSID convention. If you want to challenge the award, you don't go to any local court, you go to the ICSID convention, which shows you that there's what's called an annulment committee. That's a separate tribunal that deals with challenges to the award. So you don't go to a local court. So the terminology often used for that is the system is delocalized. There's no local court that gets involved until the last phase, which is enforcement, and we'll deal with that a bit later on. Now, in contrast, the Permanent Court of Arbitration uses the more standard, typical arbitral type of procedure. Often, I haven't seen an arbitration really use something else. They usually use what's called the UNtitled arbitration rules. So that's one of the most standard sets of arbitration procedural rules. That has a seat. So if you go to the PCA, you will need to agree upon a seat. And that seat, right, will mean that the courts based in that seat will have supervisory jurisdiction over the arbitration. They may be able to set aside the investment arbitration award. They may be able to do other, make other decisions that affect the arbitration by exercising their supervisory role. One thing I should say is courts shouldn't really abuse that right. If the courts abuse that right, or we understand the courts have the legitimate function of supervising an arbitration, but if they go beyond that and abuse that right, that may not be allowed. And there has been a couple of investment arbitration tribunals that have said certain, like there was a case against Bangladesh, SAPEM against Bangladesh, and an investment arbitration tribunal said the courts in Bangladesh in that case abused their supervisory rights, right? They went well beyond what they were expected to do under the ordinary framework of an arbitration, and they actually they made rulings saying that the arbitrator's powers are completely annulled, and the investment arbitration tribunal, looking at that system, said they shouldn't have done that. It was much more based on a sort of a it was a less legal, much more abusive power exercised by the court, and the court decisions weren't recognized by the investment arbitration tribunal. So, and again, when I'm teaching arbitration, when I'm talking about the seat, I always talk about, selecting a good seat. Where you select the seat should be arbitration friendly. They should understand arbitration. It shouldn't be a place where a court's decisions are more political or, you know, or non-legal. It should be a place where the courts understand arbitration and where the courts are stable, and you will generally understand how those courts function and decide arbitration cases. I've just mentioned other institutions that do arbitration, the International Court of Arbitration, ICC, International Chamber of Commerce, excuse me, and the Stockholm Chamber of Commerce. They do a lot of investment arbitration. And in Asia, it's quite interesting, just for just to illustrate what's happening. There's a lot of interest in investment arbitration, and institutions like CITAC from out of China and SIAC, the Singapore International Arbitration Center, they have now developed their own investment treaty rules, right? So they have their commercial arbitration rules, and they also have their investment treaty arbitration rules. So that's an interesting development, and it shows the interest arbitral institutions are showing in investment arbitration, even if they're still, you know, heavily based on commercial arbitration practice. They're looking at investment arbitration, and they're developing these rules. Now, in terms of the jurisdictional aspects, Irina touched upon this. You know, you need this sort of the dual entry. I call them like the dual sort of entry. You know, the dual gateways. The first is you need an investment. What is an investment? It really depends on the BIT to define what an investment is. You also need who is a covered investor, right? So who is covered as an investor? They're the sort of the two key gateways into establishing jurisdiction. If you can't get through, if you can't prove that you've got a proper investment that's covered by the BIT, that's the end of the story. If you're not an investor under the definition of the BIT, then again, you won't have ICSID jurisdiction or jurisdiction. I add that ICSID has this third aspect, right? So you've got the BIT definitions, but ICSID provides you with another hurdle or another sort of jurisdictional issue you need to deal with, which is in Article 25, you have the use, it says ICSID, you know, ICSID's jurisdiction relates to investments, but the problem there is that there is no definition of what is an investment in the ICSID Convention. So there are many cases trying to deal with what is the meaning of an investment under Article 25 of the ICSID Convention. I don't have time today, but you know, there's a wide-ranging type of case law about what an investment means under Article 25 of the ICSID Convention, which is undefined and still being sort of, you know, re-looked at by different investment arbitration tribunals. As for the merits, I've put down three very important sort of merits-based features of investment treaties. So in your bilateral investment treaty, you will have those substantive rights embedded in the treaty. So that, again, that's quite important, right? So you have an investment treaty under which you commence an arbitration. You look at that and you say, well, what does it say? Well, you know, I think almost all would say, you know, if a state expropriates your investment, then, you know, that's a breach of the investment treaty. So expropriation really is the taking of the property. You've got two different types of expropriation. You've got the direct expropriation. That's, you know, that's less common these days. In the old days, you would have military forces going into a factory, taking it over. That's direct. Or you'll have the title to that investment, you know, somebody's property, the title being cancelled. That's pretty direct. But these days, the interference in the property is more subtle. It's more sophisticated. So it's hard to say, oh, that's clearly an expropriation. Often I see just events, a sequence of events over a period of time, right? Not each one of those events is not enough to constitute an expropriation. But if you look at them in the sequence and you add them all up at a certain stage, that becomes, you know, that tips the scales, and then that may be an expropriation. But sometimes it's very difficult to know when the expropriation takes place, when there are a lot of small acts which you have to sort of analyze and work out, well, did this really interfere or deprive the investor's rights? Sometimes that's a problem. Like, for example, and this is just a very sort of general example. Say, for example, tax. So some tribunals have said if you impose a tax that's 99%, impose an additional 99% tax, that's an expropriation. Essentially, you've just basically you've completely rendered the investment valueless, because no investor is going to get back their profits. But then what about when does a tax become an expropriation? Sorry, when does a tax not become an expropriation? Is it 90%, 70%, 60%? It's hard to know. So expropriation sometimes is difficult. Fair and equitable treatment, it's very, it's a very broad type of protection, right? Again, no specific definition. There are many, many different interpretations of what fair and equitable treatment means under an investment treaty. It's evolving. One of the concepts that is facing constant evolution here is the concept of legitimate expectations. So if an investor, right, was told before he made the investment that he wouldn't need to do X, Y, and Z, right? He was told by a government minister who said, you don't need these licenses. He makes the investment, right, on that expectation that he doesn't need those licenses. And once he makes that investment, then the government turns around and says, oh, no, by the way, you need those licenses, right? That could be a breach of a fair and equitable treatment provision, because the legitimate expectations, i.e., that you did not need those licenses, that's been breached, right? So that's the sort of general type of issue faced there. Then you have the most favored nations clause. And I think I'm running out of time. I'm going really sort of well over time. So I'm just going to talk about this very quickly, and I'll get back because Jansen's got some very interesting points to talk about. So defenses, you can say there's no expropriation. You could say there's corruption. This and therefore that's a very solid defense if you can prove corruption on the part of the investor. And also defenses, well, the state had legitimate rights to protect its citizens, protect the health of its citizens, protect the environment. These are legitimate defenses if they're done bona fide, if they're done in good faith. And police powers encompasses that sort of legitimate right of states to govern and protect its citizens. Finally, just the last thing is you've got the ICSID enforcement mechanism. You've got the New York Convention enforcement mechanism, therefore investment arbitration decisions. So you can enforce in any of those countries. And I just wanted because we've got the Singapore element here, the Singapore Mediation Convention now, right, allows the enforcement of settlements, right? And that may cover settlements in an investment dispute. So now you've got this added extra limb of protection here, where you can, if the states are party to the Mediation Convention, if that's the case, then you're covered by the Mediation Convention, and you could get enforcement rights of a settlement agreement through the Mediation Convention. The last point I want to say is that the Mediation Convention has Article 8, where states can opt out specifically for investment arbitration types of settlements, and a number of states have done that. So that's an issue, and it's going to be interesting to see in the future whether more states apply that reservation, saying, well, the Mediation Convention doesn't apply to investment arbitration types of settlements, or whether they accept those settlements and say they are covered by the Singapore Mediation Convention. So I'll leave it there. I've covered a lot, but apologies for going a bit over time.
Professor Mantra, thank you very much for your very interesting presentation. Before I move before we will move to another speaker, I would like to ask attendees and encourage to send us questions for the Q&A sessions. because attendance is very high, and it will be very good to have those questions in the chat. Now, floor is yours, Professor Jansen Kalamita, and he is the head of investment law and policy at National University of Singapore, and also research associate professor, faculty of law. And we're very happy to have him here. As we know from the agenda, he will be speaking about the ISDS reforms, which is a very interesting topic for us. So we're ready to listen to you.
Thank you very much, Irina. It's a great pleasure to speak with you today. As you say, I've been asked to present a brief overview of ongoing efforts to reform ISDS. This is perhaps an unprecedented moment with respect to the reform of investor-state dispute settlement. So there are a great many options for reform that are currently under discussion, which I'd like to share with you today. Can you see my screen? That's the first question I have. I think so. Very good. So as Romesh, let me pick up where Romesh was, which is talking about ISDS and the trends that we've seen in the number of cases brought against states. As Roma showed, the number of claims against states has risen dramatically over the past 20 years. What's interesting to note about this statistic is that when one looks at these cases and the treaties under which the cases are being brought, what we see is that 90% of all claims have been brought under treaties that were concluded prior to 2012, which is to say that the early treaties, the treaties that states were entering into in the 1990s and 2000s towards the end of the Cold War, are really the treaties that are now providing the greatest basis for investor claims against states. And the increase in treaty claims against states has been a key driver for states to reevaluate the investor-state dispute settlement system. And I want to talk about 4 key concerns that states have looked at and addressed in animating their drive for reforms. That's concern about the outcomes of particular cases, concerns about the arbitrators themselves, concerns about the cost and duration of the proceedings, and more general concerns about procedural imbalance, which I'll talk about, the sense that states have lost control of the system that they created through these investment treaties. So, concerns about outcomes of decisions. There are 4 that I'd like to talk about. The first is consistency, and the concern that states have that there is inconsistency between the decisions of cases, cases involving similar law, same parties, facts, but ultimately different outcomes, contradicting outcomes. Examples of this are relatively few, but there are some well-known examples that put the concern into stark relief, principally the CME versus Czech Republic case and its companion case of Lauder versus Czech Republic, a case in which the enterprise which was operating in the Czech Republic brought one claim under the Dutch-Czech BIT, and the investor who owned that company, Ronald Lauder, brought a separate claim under the US-Czech BIT. Lauder lost, CME succeeded, and the facts and the law of the 2 cases was very similar indeed, leading the Czech Republic to rue the fact that they had not consolidated the claims when it was possible for them to do so. A second concern is that of coherence, and this really touches upon one of the points that Romesh was making. For example, the the variety of decisions that arbitral tribunals have rendered when interpreting Article 25 of the ICSID Convention, the meaning of investment. And here we find such divergence of approaches and divergence of interpretations, not only with respect to investment, but perhaps also with respect to umbrella clauses, to most favored nation clauses, and so forth, that states have become concerned that the system of international investment law, if one can call it that, is becoming increasingly incoherent. And so there's a concern about that coherence and a desire to find some systemic rationality through reform. There we go. Third concern is predictability. And that again concerns the outcomes of cases and the lack of ability to predict or foresee the outcome of cases, particularly due to the ad hoc nature of investor-state arbitral tribunals, but also due to the lack of binding precedent, guiding precedent, and of course the open-ended nature of the way in which many of these treaties have been drafted leads to a degree of indeterminacy as to how particular cases will be resolved. And lastly, there's concern about correctness. And in this sense, part of this concern is driven by states feeling that they've lost cases that they shouldn't have, but particularly what that operationalizes as is a dissatisfaction that there's no substantive review of arbitral awards available. As we've heard in the discussion of the New York Convention and of the ICSID Convention, the degree of review available under those treaties is exceptionally limited, typically focused only on procedural defects. And what states are looking for is perhaps something that would permit the review of awards more substantively with respect to either errors of law or even certain kinds of errors of fact. And that brings me to looking at some of the options that are being discussed to address concerns about outcomes of decisions. And these are discussions which are occurring both within ICSID as well as within Untitled Working Group 3, looking at ways to reform the system of arbitration. And what we see is a spectrum of reforms being considered and proposed, from those which would seek to improve incrementally the existing system of investor-state arbitration, to those which seek more significant structural reform, such as replacing investor-state arbitration with something that looks far more judicial and involves the creation of a standing investment court, and a standing investment court that would have an appellate function. But here, as you can see, some of the more incremental proposals being considered include the possibility of simply establishing a standing annulment committee at ICSID, which would give some consistency, presumably, and some coherence to the interpretation of the ICSID Convention, although it would not and could not address other areas for non-ICSID arbitration, to the establishment of appellate mechanisms under particular treaties, or even standing appellate mechanisms to which states might submit disputes under their treaties, to, as I mentioned, the possibility of creating a standing investment court with an appellate function. And this, incidentally, is a reform option that has already come into effect through the European Union's adoption of an investment court system for use in its investment treaties, treaties which it is by now concluded with Singapore, Vietnam, Canada, and Mexico, and is in the course of negotiating others. A second area of concern for states has been concerns about arbitrators, principally the concerns about their qualifications and concerns about independence and impartiality. Now, with respect to qualifications, part of the concern arises from the background of arbitrators and the feeling by some states that arbitrators do not necessarily possess a great enough affinity for the public law issues which arise in investor-state arbitration. Many, if not most, arbitrators in investor-state cases are drawn from the corporate and commercial bar, perhaps with experience in resolving international commercial arbitral disputes involving contracts, but not necessarily addressing the kinds of issues regarding the state's exercise of its public power in the way that an investor-state arbitration does. And currently there are no mandatory or effective rules with respect to the qualifications that arbitrators must have, or those rules which are in effect are rather general. And part of that derives from the character of arbitration and the preeminence that's given to party appointments. So states, investors are able to appoint their own arbitrators and choose for themselves which arbitrators they believe will best suit their interests in the resolution of the case. A second aspect to this is concerns about independence and impartiality. And this really does derive from the mechanism of party appointment. At issue here are concerns that certain arbitrators may be repeatedly appointed, for example, by the same law firm, leading to concerns about their independence and impartiality. Also concerns with respect to the practice of so-called double hatting. And by double hatting, what we refer to is the practice whereby an individual may serve as an arbitrator in one case, serve as counsel representing a party in another case, and perhaps even serve as an expert witness in a third case. These kinds of multiple hats being worn raise concerns about the motivations and impartiality of arbitrators. Whether an individual who is sitting as an arbitrator in one case is able to decide that case without also considering his or her role as a counsel in another case, and whether or not the decision that he or she renders in the arbitration that they're sitting in may affect that other case, or perhaps even simply provide a kind of precedent that may be relied upon in the other case. So these are the issues and the concerns that have been driving states to look for ways of reform. And among the proposals for reform that have been considered or are under consideration are, for example, the establishment of ethical codes of conduct for arbitrators. This is something that Ixid and Untitled have been working on jointly together. But again, it's also something that states individually have already begun to put into their treaties, again, notably the European Union in its new investment treaties. Other proposals include establishing a roster of qualified arbitrators who might be assigned to cases by lot, as well as the more fundamental change of simply abolishing party-appointed arbitrators and replacing them with courts of standing judges that would be appointed by the state's parties to the treaty. And again, these reforms, as we can see, they move from, on the one hand, rather incremental reforms, trying to improve the existing system of investor-state arbitration, to more structural reforms, such as replacing that system in its entirety with the establishment of an investment court system. Separate set of concerns are with respect to cost and duration. Damages awards, as is well known, can be very high in investor-state arbitration. In approximately a quarter of all cases, the amount claimed is in a range between 100 million and 500 million USD. Similarly, awards in excess of $1 billion are no longer as uncommon as they had been in the past. So states have justifiably become concerned about the possibility of being hit with tremendous awards of liability. Second, the administrative costs. On average, an arbitration costs the state approximately $1 million in terms of administrative costs. That is nothing compared, of course, to the legal fees that the state is likely to incur in defending itself in an investor-state arbitration. The average approximately is estimated to be $5 million for a state in an investor-state arbitration. There's also then the issue of cost recovery. At the moment, it is unpredictable at best as to whether or not the state will be able to recover its costs in the event that it successfully defends itself. And that's rooted in both rules of arbitral rules, which do not specifically apportion cost recovery in the event of loss to the investor, but also the problem of impecunious investors, investors who actually have very little operating capital at the time that the claim is brought, and who cannot pay an award of costs in the event that the arbitral tribunal renders one. And that ties in with the phenomenon of third-party funding. Third-party funding has developed as a very active process for funding arbitrations over the past 10 years or so, and effectively entails third-party investment companies providing funding to claimants in exchange for some part of the award that the investor might win against the state. This, of course, can lead to impecunious claimants who do not have funds themselves, but are rather being funded by a third party, which may or may not be subject to an awards, to a cost award. But it also creates an asymmetry in the system whereby it's really only claimants which are able to have access to third-party funding, because it's only claimants which are typically in the position to recover large amounts, which incentivize third-party funders rather than the state, which is only in a position to simply avoid liability. And finally, there's the length of the process. On average, a claim which goes to the merits takes 3.7 years to conclude. And that, of course, is time during which the government and its officials are otherwise working on defending the government rather than the day-to-day business of the people. Some options to address these issues have also been raised. They range from simply improving management practices in investor-state arbitration, by the arbitrators themselves, setting deadlines and so forth, to improving mechanisms for the resolution and dismissal of frivolous claims, providing security for costs, and clear rules on cost allocation, all designed to improve the efficiency of the system. And finally, I'd like to address these concerns about procedural imbalances. And here again, this is about states being concerned that through the arbitral process, they've given up more control with respect to the interpretation and application of their treaties than they had intended to. And here's some of the proposals for reform include mechanisms whereby states can enter into joint interpretations with respect to the interpretation and application of their treaties, joint interpretations which would be binding on arbitral tribunals deciding cases under those treaties. Referral mechanisms whereby disputes regarding particular types of measures, say for example taxation, could be referred first to the parties themselves and perhaps their entities responsible for those matters. So perhaps the tax authorities would first take a look at a claim being brought by a foreign investor to determine whether they believed collectively that this claim was one which should go forward or not. Thirdly, there are proposals for increasing the use of non-disputing state party submissions. Already this is provided for under the Untitled rules on transparency and investor-state arbitration. But this effectively allows the party to the treaty, which is not the respondent in the case, to make a submission to the tribunal on its views as to how the treaty should be interpreted and applied. Fourth, there is the possibility of simply limiting the scope of the arbitration clause to eliminate either certain types of investors or certain types of claims. For example, the Australia-Singapore FTA precludes claims based on tobacco control measures. Other treaties may preclude claims by those who simply hold portfolio rather than direct investment. And ultimately, any or all of these can be combined with simply the replacement of ad hoc arbitration with standing investment courts, which again is a proposal that is seen by some states as being a way of regaining control over the system of investor-state arbitration. And in that respect, as I close this discussion, we can take a look at where states currently stand in terms of the debate, at least as it's playing out in UNCITRAL Working Group 3. On the one hand, there are significant states which are not yet convinced, perhaps they never will be, that there is the need for structural reform. Rather, they see investor-state arbitration as a viable mechanism, but simply one that needs to be improved through the kinds of incremental reforms that I've been talking about. And here we see the United States, Japan, Russia, principally staking out that position in the debate. Other states have taken a clearer view that they believe structural reform is necessary. And as I mentioned, the European Union and its treaties has already replaced investor-state arbitration with investment treaty courts under those particular treaties. And in the context of the UN, the European Union and Canada particularly have been proposing to multilateralize that approach, to create a multilateral investment court, which could be a standing court with a court of first instance and then an appellate body, replacing party-appointed arbitrators and available to hear claims arising under any investment treaty. Other states don't appear to be willing to go to that level of reform at this point, but are nevertheless interested in establishing some kind of appellate mechanism which could have a more substantive review of investor-state arbitral awards. And here China, India, and Argentina have expressed their views on this subject. And then finally, it's worth pointing out that there are other states like Brazil, which might be thought of as shifting the entire paradigm of investor-state dispute settlement. Over the past 4 or 5 years, Brazil has concluded a number of treaties which provide for investor protection, but seek to resolve disputes arising under those treaties, not through investor-state arbitration, but through either localized ombudsperson mechanisms or ultimately, in the event of unreconcilable disputes, through state-state mechanisms. So taking the investor out of the picture for dispute settlement altogether. Finally, there has been a great deal of interest in all of this with respect to alternative dispute resolution, even for states which are content to continue with a system of investor-state dispute settlement, whether it be before a court or through arbitration. There is real interest in mechanisms for resolving these disputes through either mediation, conciliation, and so forth. And as Romesh has already mentioned, the Singapore Convention on Mediation provides a potential framework for promoting that type of resolution by creating an efficient and harmonized framework for the enforcement of international settlement agreements resulting from mediation. And lastly, one aspect of this discussion as well is states pursuing strategies for avoiding disputes in the first place. And that means looking at ways to inform government officials about the investment treaty obligations that the state has entered into, so that they are less likely to violate those commitments, certainly inadvertently, creating early warning mechanisms which allow relevant authorities within government to have early sight of potential problems with foreign investors, and establishing ombudsperson mechanisms, which again provide investors with a local source of remedy rather than having to, or rather than ultimately seeing those disputes spiral into full-blown arbitrations and investment treaty disputes. So thank you very much. That's been a bit of a whirlwind, I realize, but there is a lot of reform currently under discussion, and thank you very much for your attention.
Thank you very much for a very interesting presentation. We're opening question and answer sessions, and we have a couple of questions in the chat, and you're also encouraged to send the other question, as we have at least eight minutes to answer them. Firstly, I would have a question to the professors from Singapore. What they think about the Georgian Additional Investment Protection Law standard, which actually sets the different standards for the special status investments. What do you think, and also if it will create any inequality problems in the future, if you think, and also those special status investment contract terms are also public, and what do you think if it will raise confidentiality problems or not in the future? If you would, we will listen your just your overview and your thoughts about it. Could we take the questions, and then we will be answering how we prepare?
Irina, can you just give me, I'm just a bit unclear about the Georgian sort of the special status. Is there an issue there about, discrimination between, investors of different countries, or does it apply across the board to all investors?
No, this applies to all investors equally, but they are giving special status to investors who are investing in Georgia more than 800 GEL. And they have this kind of special status, and includes that Georgian country gives them some special help while investing in the country. This is just a difference, but the contract terms are public, and if this creates any problems in the future, I would.
It seems like something that's, if it's done legitimately, if it's done for a bona fide purpose, right? Mm-hmm. It's not like a disguised sort of way of trying to limit certain investors. It's very difficult to prove, but those sorts of laws, it's within this legitimate framework of sovereign powers. But if it's abused, if it starts looking like it's not bona fide, if there's a bit of bad faith, if it's used to target certain investors, then potentially that's not. But and apologies, I don't know the specifics of the law, but that they would be, whenever I get questions asked in this general way, I think that sort of bona fide type of aspect is very important.
Okay, thank you very much. We have another question from Chula Leng Ing, and he is asking about regarding to legitimate expectation under fair and equitable treatment, and saying that what is the investment tribunal view on the principle of legitimate expectation? Should omit or limit the scope of it? How they are doing it? This is a question. And the second question is from Ms. Khatia Sebua, who is asking about regarding the claims arising out of more than one contract. How would the arbitration be commenced when the preference is for all the claims to be heard in one arbitration proceeding? And we have another question from Ms. Faterani, who is asking if the tribunal consists of a sole arbitrator and he is found to be corrupt and accepting bribes from one of the disputing parties, would the award still be binding? This is his question.
Janssen, please feel free to just jump in on any of those questions, and I can answer after you. Yeah. Or would you like me to start?
No, thanks, Romesh. I'd be happy to speak to the one about legitimate expectations and leave the others to you. The answer is that there's no simple answer with respect to the meaning of legitimate expectations, and that's been an issue for states. What we do see states doing is increasingly in their treaties providing additional clarifying text to explain what they intend with respect to legitimate expectations. So, for example, pointing out that simply the fact that an investor has had its expectations harmed as a result of a government decision is not in and of itself sufficient ground to find a violation of fair and equitable treatment and so forth. But this is one of those issues, as Romesh was saying, the text itself doesn't generally provide a great deal of information for the tribunals. And so tribunals continue to interpret the clause in sometimes very different ways.
Thanks, Janssen. I'll deal with the two other questions. So, you know, if you've got separate claims, can you deal with it in one arbitration? Gets back to the consent point. I think generally, I think the standard answer would be you'll need the consent of all the parties. Okay. If you don't, I think you're getting into territory where one party will say, you know, I did not consent to this, therefore the procedure does not apply to me. You cannot bind me when I don't consent to this procedure. But another option could be, well, what's the wording in the bilateral investment treaty? Does it provide for this? I haven't seen many that do, but in, say, for example, in commercial arbitration now, they're starting to develop rules where they're trying to sort of have consolidation, even where, you know, there's not full sort of consent, but it's obvious that all of these claims arise from the same dispute, the same sort of issues, same contract, same arbitration agreement. There is more and more sort of willingness of institutions to consolidate, but that's commercial arbitration. It hasn't really got to investment arbitration yet. I think it's much more strict in investment arbitration. So my basic answer there would be, you need very specific consent. If all parties agree, yes, but if they don't, I think you've got a problem. And finally, the corrupt arbitrator, that's pretty easy. Of course, if an arbitrator is corrupt, is accepting bribes, obviously that breaches international public policy. You will not be able to enforce that award. You will likely be able to annul or set aside the award on grounds of public policy. You you know, international tribunals will say, well, sorry, international courts or you know, looking at this will say, we cannot give weight or value to anything that's been done by a corrupt arbitrator, I think, and that's a pretty easy question for a review tribunal or court to do if they're looking at that situation where the maker of that decision has been corrupt.
Thank you very much for the answers. As we are running kind of out of time, and we have very busy speakers here, we can conclude here. And if our distinguished panel members has some closing remarks, we can receive that, or Nino will conclude the webinar.
Very, very happy to have been participating in this, and you know, we're always free to have any other questions. If they can get directed to CIL, we'd be very happy to respond by email.
Thank you very much.
Thank you very much.
And just to add, it's been my pleasure to travel to Georgia twice to work on some investor state matters, and I only hope that in the future, if we organize one of these things, we might be able to do it in person in Tbilisi. Thank you.
Thank you very much.
I would also like to thank you for inviting me and making it possible for me to participate in this event. It was very interesting for me as a listener. And I got some new knowledge about investment arbitration and the problems related to it. So far, we did not have any investment arbitration award which would be recognized and enforced in Georgia. So it was very interesting to hear what are the problems related with investment arbitration and what challenges might be there and how to face them. So thank you again, and I feel really honored and pleased to be part of this event, and I hope that in future the cooperation will continue. This has been very interesting example of this cooperation, and I think that it won't be last. It will be just a beginning.
Thank you very much.
Okay, thank you very much. Unfortunately, our first joint session and webinar finished. It was very interesting, and I'm very exciting that, and I am very happy that I was a host of the first joint seminar and first joint project with CIL and GLIP. I hope that our future collaboration will continue, because I am sure that these projects and this cooperation will be very fruitful for Georgian lawyers, for Georgian bar members and practicing lawyers. Thank you. To our great speakers, presentations were very interesting, and also I want to say special thank you to the director of CIL, Professor Oral, also Professor Romesh Viramentri, Professor Kalamita, and Justice Nino Bakakuri. It is very my honor to be host today's seminar, and I hope our collaboration will continue, and we will be back very soon. Thank you.